Did Aiden straighten her hair today? All right, it's a bones day. Get out there. Is it curly? Oof, maybe we should have stayed in bed. Hello friends, welcome back to All Up in Your Business. I'm business and branding attorney Aiden Durham with 180 Law Co. in Colorado. And it's that time again, my favorite time of the month. We are going to rifle through your comments and answer some of your great questions. Now, bear with me through this, you guys, because it is Friday over here at All Up in Your Business. I'm posting this on a Wednesday, of course, but I'm filming it on a Friday. And you guys, Friday Aiden is either very productive or very lazy. And if the curly hair isn't a dead giveaway, we're getting lazy Aiden today. It's kind of like that Noodle the dog, bones, no bones thing. You know, if Noodle has bones, it's Bones Day and everyone's excited and productive. If it's a no bones day, then, you know, it's a sad day and everyone stays home. Kind of like that. Did Aiden straighten her hair today? All right, it's a bones day. Get out there. Is it curly? Oof, maybe we should have stayed in bed. But alas, here we are on a Friday, curly hair nonetheless. Before we get into your questions, make sure you check the description for links to additional information and resources. You can download my brand new, all freshened up Brandish trademark guide for free. Link in the description. Be sure to subscribe if you haven't already done so and hit that little notification bell so you don't miss any future episodes of All Up in Your Business or any future episodes where I might be answering your questions. And if you're, bored, looking for something to do, if you're watching this on your computer or your TV, why don't you get your phone out and, pull up Instagram and search at All Up in Your Business and give me a follow. Let's be friends. All right, enough of that nonsense. Let's get into your questions. Question: if I have a LLC and I added a DBA, could someone use my DBA name for their LLC? Or does the DBA under my LLC stop them from access of the name? So this is something that I kind of touched on my last episode where I talked about LLCs versus trademarks. But registering a LLC name really, for the most part, only prevents somebody from registering that exact same name, including the LLC designation in that same state. Same idea pretty much goes for DBAs. If you register a DBA or a trade name in most states, that won't prevent somebody from registering that same name as their LLC or corporation name. So, of course, it always depends on the state. There might be some states where that is the case, but for the most part, as far as I know, no. Having a DBA won't prevent somebody else from using that DBA in their LLC name. Are member contributions tax-free? Typically, yes, but it depends. Not all member contributions are going to be void of any tax implications. So it depends. Chat with a tax expert. What can I do if I've got some business expenses on my personal account by accident? Best thing to do, you can reimburse yourself from your business account to try to make that right, and then be extra careful moving forward to not accidentally use your personal account for business expenses. You know what I really like, and I might take this tactic on a few things. I have a lot of fun answering just the questions that are asked. If you've ever worked with a lawyer in any kind of legal dispute or lawsuit, if you've ever been in a deposition, you've probably been advised by a lawyer, answer only the question that's asked. Don't volunteer any additional information. Answer just the question that's asked. I like doing that. I might start doing that. I want to trademark a name as an actress, like a stage name. I've been using this name on Instagram and casting websites. I would also use this name when I get into writing books and blogs. Anything important I should know. Also, for this, does the font theme matter when submitting if I'm using the name in this way? All right, so going back to the whole thing of I'm only going to answer the question that's asked. Anything important I should know before I apply? Yes. there are a lot of important things you should know before you apply. Talk to a trademark lawyer, or you can check out Brandish, my online DIY course, which will help to teach you a lot of those things that you should know before you apply. And does the font matter? If you are submitting a trademark as a standard character mark, then the font doesn't matter. I just found your page and the information is extremely helpful. Thank you. I just started a sole proprietorship, but it looks like I made a new change to an LLC. Is there a way to transfer or change from sole prop into LLC, or do you have to completely start over, brand new? You don't have to start over. You can kind of change your sole proprietorship to an LLC. I made a few videos about this. I posted one recently. I will link to that in the description and put up a little card on that side. I don't know. There'll be a card here for that. But yes, you can. You don't have to start brand new. You would form an LLC, and then some things you have to kind of transition or transfer over to the LLC from your sole proprietorship. So check out that video for more. So when a client wants to pay for a service under the DBA name, they would write the check to the LLC name or the DBA name. It depends on what the bank has and will accept. If you tell the bank that you operate under an LLC name and a DBA name, typically they'll allow you to accept checks under both. If they only have the LLC name, then you should only be accepting checks under the LLC name. If you only have the DBA name with the bank, then you should only accept payment under the DBA name. Otherwise, if it's both, then you can accept payment under either or both. That's fine. Second question from the same person: how many DBAs can you have under your LLC? As far as I know, there are no rules or limits. You can have as many DBAs as you would like. Of course, check with an attorney in your state. There might be some state that has restrictions. As far as I know, there aren't. So this is a trademark question. I've discussed in previous videos about specimens for trademarks and how the mark needs to appear the same on the application as it does in the specimen and as you're using it. So for use appearing different, does that include color variations? For example, we're trademarking a purple, yellow, and blue logo. Our paper tags, the logo appears in the same color, but on our products, it's in different colors. So with color variations for a design like a logo, if you submit the application and claim color as a feature of the mark, then the color of the mark in the drawing needs to be exactly the same as the color in the specimen. If there's a difference in color, then the USPTO won't accept it. But if you submit the drawing on a black and white or gray scale and do not claim color as a feature of the mark, then on the specimen, the logo can be in whatever color or colors you want it to be. Second question from this same person: for date of first use in commerce, does it include first time used on social media, on website, first use for pre-sale of products, or only when the product is actually purchasable? Pre-sale is not typically considered use of a trademark. Neither is just launching a website or launching social media accounts. This isn't a strict rule, but the easiest way to think about it is when the product is actually available for purchase. That's when you've started using the trademark in connection with that product. I have a good question for you. I'll be the judge of that. Thank you. Is it possible to change the filing date after I receive a response to office action? The reason for that is I don't have any pictures to prove the first use in commerce anywhere. To change the filing date? No, you can't change the filing date on your application. You can sometimes change the date of first use. You can amend the date of first use if you put the date of first use incorrectly. But if you don't have proof of use, then there wouldn't be a date because you're not using it. What you can do is amend your filing basis to a 1B or intent to use filing basis, and then you'll have time, 6 months at least, before you might have to submit that proof. So if you're not already using the trademark in commerce, then your best bet is to amend to a 1B intent to use basis. Can you be under 18 to register an LLC? It depends. It depends on a number of things. It depends on what you mean by register a LLC. Can you be under 18 to own or be a member of an LLC? Yeah. At least in most states, as far as I know, there are no states that say you have to be 18 to be a member of an LLC. That is sometimes different from registering or forming or organizing an LLC, though. Many states, if they define an organizer, many states will require the organizer to be 18 or older. Some states might require a manager to be 18 or older, like a manager and a manager member, manager managed LLC. Pretty much all states, I'm almost certain all states require the registered agent to be 18 or older. But as far as being a member, yeah, a child, someone under 18 can be a member of an LLC. Is that a good thing to do is a whole other question. There are a lot of issues that can come up with that because minors signing contracts and in binding legal agreements gets iffy, and that's not always a good thing to do. So it depends. It depends. Kind of, yes, but also no. It depends. Can you explain this to me? No claim is made to the exclusive right to use the following apart from the mark as shown, restaurant. I am confused. What does this mean? So this is a disclaimer in a trademark. This is the language that we see for a disclaimer in a trademark registration. I've done a previous video talking solely about disclaimers. So if you want more info, check back for that. But basically, when you see this in a trademark registration, or if you are asked for a disclaimer, it's usually a disclaimer of a descriptive term. So in this case, I would imagine the trademark is a restaurant or some kind of food service, and their trademark includes the word restaurant. That word describes their goods and services, so it has to be disclaimed. All that means is that you don't have any exclusive right to use that disclaimed term except for how it's being used in your trademark. In other words, you can't take down or go after somebody else who's also using the word restaurant just because they're using the word restaurant. You're not claiming any exclusive rights to restaurant except for how it's used exactly in your trademark. My husband's logo designer told him he won't give him the rights to his logo and that he has to let him file for the trademark for $1,200. Can he do that? He can withhold the rights to a logo. If you hire somebody to design a logo for you, it is very, very important that you have a contract with that designer that says that they are assigning or transferring all of the right title and interest in the work that they created. Some language to the effect saying that you, as the person who hired this designer, you get all the rights and you can use the logo however you want, or in some way. If that's not the case, if you don't have something in writing, then yeah, technically the designer owns the rights to the logo. The second part of having the designer file the trademark for $1,200, that's wrong. If the designer's not using the logo as a trademark, then the designer shouldn't be filing an application as if he is using it as a trademark. So the first part, yeah, he can do that. The second, no, he can't. Thanks for this video. If I want to trademark my business name, logo, and website name, do I need to complete 3 different applications? Yes. Each trademark is its own application. A business name is its own trademark. A logo is a trademark. A website name is probably, I'm assuming, is actually a trademark here, but 3 separate trademarks, 3 separate applications. Do you have to have a licensed business to apply for a trademark? Nope. Doesn't matter if you're registered, licensed. I mean, if you're running a business and you need to be licensed for some other reason, then you should have a license. But as far as the trademark goes, nope, USPTO doesn't care if you have a license or not. You can be a sole proprietorship, a general partnership, as long as you're using the trademark as a trademark. That's pretty much all that matters. Hi, Aiden. Excellent. Thank you so much for your insight. Does the operating agreement replace a partnership agreement? I'm setting up an LLC for my partner and I to manage. Should we have a separate partnership agreement? No. So the operating agreement does replace a partnership agreement. A partnership agreement we would typically see in a general or maybe a limited partnership. Operating agreement is the same kind of idea, but in an LLC. So yeah, you don't need a operating agreement and a partnership agreement, typically with an LLC. Thank you so much for your brilliance and guidance. You're welcome. What's your take on this new world of protection in the form of things like NFTs instead of copyrights or trademarks? Do you think traditional methods are still stronger? This is a well-timed question. I am going to be putting up a video in the next few weeks where I talk about NFTs. It's not a question of NFTs instead of copyrights or trademarks. It's NFTs and copyrights or trademarks. How do NFTs apply with copyright and trademark law? Because ultimately, I'm going to talk about this more, but ultimately NFTs are protectable by copyrights and trademarks, just like anything else. So stay tuned. I will cover this eventually. Hello, I already have a trademark with a bag, backpack, wallet, and so on. My question is, can I use this trademark to the different product like lipstick? So this person has a trademark registration, I'm assuming, registered with respect to bags, backpacks, wallets, and so on. Can they use it also with respect to other products like lipstick? Can you? Yeah. Will your trademark registration apply and protect your use with those other products? Not necessarily. It depends. Best thing to do if you want to use your trademark on different types of products would be to register or apply again to register the trademark with respect to those other goods and services. Love your videos. Thank you. Question: did you say that trademark cannot be a group of words together like toy mover? No, I did not. That's perfectly fine. Words can be separated or together. That's totally fine. All right, we did it, you guys. Well, somehow I've managed to make it through this without quitting or falling asleep. All right, well, hope you guys had fun. I had a great time. If you learned a thing or two, why don't you give me a little thumbs up and make sure you subscribe and check the little the little bell so you don't miss future episodes. What other stuff am I supposed to say? Smash that like button. Follow me on Insta. Check the description for links to additional information and resources, free guides, all kinds of good stuff for you guys down there. Thank you so much for watching. I'm Aiden Durham, and I will see you next time.